I'm going to introduce Clarke Forsythe. For any of you who've been friends of AUL or followed AUL, you know Clarke. He's a senior counsel. He's served in all roles, really, at AUL. Very experienced and respected legal writer and thinker. And his new book that I want to mention for you will illumine some of the things Jerry was talking about in the Roe decision. It's a comprehensive, really, analysis of what went on behind the scenes, and it's called Abuse of Discretion, the inside story of the Supreme Court's creation of the right to abortion, and it'll be published by Encounter Books in September. Clarke.
Thank you very much, Bill, and thank you all for being here for another distinguished panel. Their extended bios are in your materials, and I would encourage you to read them thoroughly. They're all very interesting. And I'll just give a few brief highlights before I give some introductory remarks. Dr. Laura Garcia received her doctorate in philosophy from the University of Notre Dame and has been a member of the Boston College Philosophy Department since 1999. Her recent publications include Authentic Freedom and Difference in a book entitled Women, Sex, and the Church, edited by Erica Bakayaki, which I would encourage you to take a look at, and Preserving Persons, published in a volume entitled The Contribution of John Paul II to Bioethics. She is currently editing a book of essays entitled Truth, Life, and Solidarity, Philosophical Implications of the Thought of John Paul II, and her lecture last year at Xavier University in Cincinnati entitled In Defense of Male-Female Complementarity will be published as part of the university's Ethics, Religion, and Society lecture series. Ed Whalen is president of the Ethics and Public Policy Center here in Washington, and he has advanced that organization and its influence under his stewardship. He's a former law clerk to Supreme Court Justice Antonin Scalia after graduating from Harvard College and Harvard Law School, and he is a leading contributor to National Review's online Bench Memos blog, where he writes my favorite blog. Helen Alvarez is an associate professor at George Mason University's School of Law, and she is a prolific writer of essays and very interesting and thought-provoking law review articles. She's been published in many leading law journals across the country. She's recently edited a book entitled Breaking Through, Catholic Women Speak for Themselves, and I'm looking forward to getting into a manuscript law review article for Villanova Law Review entitled No Compelling Interest, the Birth Control Mandate and Religious Freedom. But before they give their remarks, I need to give some context and explain how we got here today. 40 years after the Supreme Court's abortion decisions, they remain intensely controversial. In fact, I think by almost any objective measure, Roe versus Wade is the most controversial Supreme Court decision since Dred Scott, the 1857 decision which prohibited Congress's limitation of slavery in the Western Territories and heightened North-South tensions leading up to the Civil War. I mean, the hundreds of thousands of people marching tomorrow on the Mall are not there because of Gideon or Miranda or any other Warren Court decision. They are there, they have been there every year for 40 years for one reason, Roe versus Wade. Now, of course, what we call Roe versus Wade is really two cases from two states, Roe versus Wade from Texas and Doe versus Bolton from Georgia. These two cases were argued together, decided together, and issued the same day. But the Doe decision has been relatively and typically ignored over the past 40 years, despite its significant impact on abortion policy in the United States. And that has skewed academic understanding and public understanding of the impact of the two cases. Because the court said that Roe and Doe, quote, are to be read together, unquote. And in Roe, the court created this right from conception to birth for virtually any reason, but then suggested that the states could prohibit abortion after fetal viability and here's the key phrase, quote, except where it is necessary for the preservation of the life or health of the mother, unquote. But then in Doe, the justices defined that health exception as, quote, all factors, physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient, unquote. That's why health, uniquely, in abortion law means emotional well-being without limits. This health exception swallowed the supposed ability of the states to prohibit abortion even after fetal viability. And there are several more reasons why the justices have caused 40 years of turmoil and unrest in this country over the abortion issue. First, Roe versus Wade began as a mistake. The justices took two cases in April 1971 to decide the very obscure issue of jurisdiction between state and federal courts. And then, later in the year, a four-justice block decided to use the cases to eliminate the abortion laws. Justice Blackmun related this story to at least two people, and it's confirmed by the briefs in the cases, the justices' papers, and the oral arguments. In a letter to then Chief Justice Rehnquist in July of 1987, and that date is important because it was the summer before the Bork hearings began, and Chief Justice Rehnquist was worried about the court being shorthanded if the Bork nomination was not successful. He was concerned about the court being shorthanded in the fall, and Blackmun wrote to assuage his concern, and he wrote the following. He said, quote, I remember that the old chief, Warren Burger, appointed a screening committee chaired by Potter Stewart to select those cases that could, it was assumed, be adequately heard by a court of 7. I was on that little committee. We did not do a good job. Potter pressed for Roe versus Wade and Doe versus Bolton to be heard, and did so in the misapprehension that they involved nothing more than an application of Younger versus Harris. How wrong we were, unquote. Younger was that state federal jurisdiction case. And that's how the justices ended up with two cases with no evidentiary record whatsoever about abortion or its risks or its implications. Second, there's reason to think that Roe was really an historical accident due to twin vacancies after the abrupt retirements of Justice Black and Justice Harlan within a week in September of '71 due to ill health. That flipped the balance of the Supreme Court in September of '71, and a temporary majority of 4 justices, Douglas, Brennan, Stewart, and Marshall, pushed to use the two cases to create a full-blown right to abortion. Third, the outcome in Roe versus Wade was driven by a medical myth that abortion is safer than childbirth. And you can read this in kind of between the lines in both Roe and Doe. But there was no reliable data in 1972 to justify this, and certainly there was nothing in any record. No existing obstetrical textbook in 1972 made such a claim. And again, there was no evidentiary record. But a review article that I think Professor Coleman mentioned earlier, published earlier this month in Scientifica, the online journal by Dr. John Thorpe of UNC Chapel Hill, explains why that medical myth that abortion is safer than childbirth is still nonsense today. Fourth, it was based on that medical myth that the justices proceeded to prohibit health and safety regulations in the first trimester, when 90% are done, and created the public health vacuum that we see in Kermit Gosnell's clinic in Philadelphia and Stephen Chase Brigham's clinics in Maryland and New Jersey and Pennsylvania. And fifth, a month before the decisions were released, the justices arbitrarily expanded the right to abortion that they were creating from 12 weeks gestation to 28 weeks, a full 16 weeks, a full 4 months, and arbitrarily adopted a viability rule that was never briefed or argued. In fact, in 4 hours of oral argument in December of '71 and October of 1972, the word viability was not mentioned even once. As a result, Roe versus Wade is way out of line with international standards. Roe isolated the U.S. as one of 4 countries out of 195 around the globe that allow abortion for any reason after fetal viability, and those 4 nations are the U.S., Canada, China, and North Korea. Roe is way out of line with American public opinion. which supports abortion only in certain circumstances early in pregnancy. And American tort law and property law and criminal law, as Professor Bradley noted, have rejected the viability rule. The states have moved ahead with legal protection in most of these areas from conception. And a growing body of international data over the last 20 years suggests significant long-term harms, long-term risks to women from abortion that you heard about from our medical panel. More specifically, there's a growing body of international medical studies, statistically significant and peer-reviewed, that specifically find an increased risk of preterm birth after abortion, an increased risk of mental trauma, and an increased risk of breast cancer. Today, in 2013, it seems that the public authority of Roe is largely based on fear. The fear that by overturning Roe versus Wade, the Supreme Court would make abortion illegal. But the irony is, if the Supreme Court overturned Roe versus Wade today, abortion would be legal tomorrow, up to fetal viability in 42 or 43 states, for the simple reason that there is no enforceable legal prohibitions in 42 or 43 states. And as Bill mentioned, all of this I lay out more fully in my book, Abuse of Discretion, that will be published by Encounter Books in September. Those are the two cases that we deal with today. Professor Garcia?